I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. You can't even follow the rules in jail. I cannot imagine the fear, but terrorize him for quite some time, pulling him around, yanking him around, putting guns in his face, all three of you. Good morning. Are you Caden
Yes.
Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense. Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So I don't need to call my custodian record. With the court's permission, first of all, I'm offering states one. No, Judge.
Make that states two, because this one was the plea admonishment documentation, please.
I'm offering states two. No objection.
States two is admitted.
Permission to publish, Judge.
Yes, sir.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough.
Okay.
Oh, would you switch that back to the other?
All right. I thought I did. Yeah, back on camera image.
Which you might too.
Oh, you want to pick them?
Try one.
Okay. Well, HDMI one is a laptop.
Not fine. HDMI two as well. Here we go. Thank you. Any other evidence, or witnesses?
So just brief argument if I may.
Any other evidence or, witnesses for, Mr. Rojas?
No, Your Honor, just
Mr. Rojas, you may make argument first.
thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. In Mr. Fontes' defense, he is a young offender. I know the court is tired of hearing the same story over and over again, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom at home, trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontenot that we've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road to prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer, because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all of that stuff's fine, but you, Judge, are where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking. I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're going to pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenot, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do. on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. Going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff. Paul Jackson, Mr. Rojas.
Jackson.
Good morning. Are you Paul Jackson? And Mr. Rojas, for your client, waive the formal reading of the indictment.
Here we are.
Mr. Jackson, in clause number 26, DCCR 0112, you're charged with the first-degree felony offense of aggravated robbery. And that's from January 5th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yeah.
So I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. It shows me that there is no agreement in your case and that you're leaving your punishment up to the court. Is that correct? So you're wanting probation. The state is asking me to send you to prison. It'll all be decided when we come back here later. And I'll look at the underlying offense. I look at any evidence that your attorney brings me, anything that the state brings me, and then I can decide to sentence you anywhere in the range of punishment, which is from probation up to between 5 years and up to life in prison. Do you understand? Do you understand?
Yes.
And there's no agreement, which means you would have some rights to appeal depending on how that goes and what I do. Do you understand that as well?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. I also want to make sure, Mr. Jackson, that you understand you have an absolute right to have a jury come in and determine two things. You can have the jury determine if you're guilty or not, and then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? So you can either do what you're doing today, that you've signed on the paperwork and leave your punishment up to me, or you can go to a trial and let a jury decide. Okay. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
I'm done speaking English, so I'll translate.
Thank you very much. Argelio Arellano. I'm sure I did not say that even close to right.
What did you say? I didn't hear you.
That I try.
You gotta do it again, Judge.
Hmm.
You gotta do it again.
I know. And for the record, Mr. Rojas, you're going to translate for us. Is that correct?
Yes.
Good morning, sir. Are you Argelio Arellano?
Yes, good morning.
Oh, me contestas en español. Oh, eso está bien.
Sí.
Yes,
And will your client waive the formal reading of the indictment?
he will, Your Honor.
Mr. Arellano, in cause number 21-38292, you're charged with a third-degree felony offense of smuggling of persons from July 28th of 2021. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes. Yes.
Do you fully understand them?
More or less.
Well, let's go through it. Do you understand that if I follow the agreement that you made with the district attorney, that you will not be able to change your mind or appeal your case?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Is there anything else that you don't understand that you want to ask me about?
Well, that's all.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arellano is not competent?
Oh, yeah.
Right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of smuggling of persons. Sentence you in accordance with that agreement to a term of 2 years, in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. So you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish. Please read it carefully because possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right. Good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Rojas.
Thank you, Judge.
Still nothing from Mr. Bynum. Yeah, that was. Thank you, though. That's sweet. All right. I wonder if anybody's here. Is anyone here for Louisa Magruder? Just in the audience? We're just trying to figure out where her attorney might be.
I have not.
Okay.
Not from the phone or.
Is Mr. Lewis back there working on some stuff? All right, we'll just let him work on that and I'll take. To get a job and do all of those things. And they're there to help you do that. Okay. So if you're feeling like you can't do something or you're struggling or you don't have support at home, probation's there to help you. They're not trying to trip you up. Nobody wants you to spend potentially the rest of your life in prison, but that is going to be 100% up to you at this point. You're going to have to ask for the help and make that change and grow up and be more mature at a younger age. Do you understand?
Yes, ma'am.
The last thing is that a condition of your probation is that you do not get any incident reports in our jail or in ISF. That will be a violation of your probation. And you're going to, if you do that, you'll be back in court before you ever get out and see the light of day again. And you could be looking in each of these cases at a minimum punishment of 5 years up to the rest of your life in prison. And based on the nature of these offenses, it's not going to be y'all coming in here and arguing for some 2, 3, 5, or 5, 6, 7 year sentence. I'm sure Ms. Malvino is going to come in here and ask for something huge. It depends on what happens. I can't prejudge it, but I'm telling you right now, you better not get in trouble because that's the one thing that you've been doing that's been extremely frustrating to me. So you've learned how to do it. Whatever you're doing, you're staying away from the riffraff out there, and I appreciate that. Continue that. Do what you're supposed to, and you'll be able to change your life and be hopefully a success story.
Yes,
Do you understand? A condition of your probation also, excuse me, in each of your cases, you are not allowed to possess a firearm at all. That means obviously you personally possess one. You can't be in a car with someone else that has one. You can't be in a house with someone else that has one. Somebody has one, you're out of there. Do you understand?
Yes, ma'am.
Okay. I'm handing you the trial court certification in each of your cases that shows that these were agreements that I followed. And so you've waived your right to appeal. Again, keep doing what you're doing. I'm really hope that you have, I'm impressed that I haven't gotten another incident report. And so I want to acknowledge that and tell you that I know that takes a lot out there and I appreciate it. Continue that.
Thank you, ma'am.
Yes, ma'am.
If I may, would the court consider continuing the admonishment that you'd given him previously about no contact with Gerard Crane or any of the other participants? I do not know who they are. He knows who they are. He knows who he was hanging around with
Sure.
from his high school class.
So
just so that
obviously you're not going to hang around Jared Crane because we know him, but there were others that were involved. You need to, and you're going to learn at ISF that when you come back out of ISF and you're on probation, that you've got to put yourself in different situations around different people. Get a job, go to school, whatever it is, go do that, go home. You know, the hanging out, if you're caught doing that with people that are also in trouble, then you're just gonna be right back in there with the violation. Okay, all right, you go back with the bailiff.
Thank you, Judge. With the prosecution, I'll dismiss those cases.
Thank you. I'll sign those when they come through. Is Mr. Frank Adams here? Mr. Bynum?
Yeah.
Mr. Eckhart, you've got Robert Trahan.
Hey, Judge, he told me he's hired, right, I've been able to come out.
Trying to confirm that.
Okay, let me hold that one just for a minute.
I think.
Is Mr. Kevin Lane
Yes, Your Honor.
on Alexis Bourgeois Cooper?
She's in custody.
So do I have, that was a no-show for sentencing. Is there a PSI window?
There is, Your Honor.
Okay. Oh, you might have to find that. I don't know if she had it pulled because it was a no-show, so it just got reset. So we'll find mine because I need to probably have notes of that. There we go. Yeah.
Cooper?
Yes, Bourgeois Cooper, Alexis. Good morning.
Still, and you have house sweater.
I like it, but I gotta get something new to use.
Is that right? I got you from Amazon.
Yeah. It took it off so long, it did. Well, last time.
That's exactly what I was
She's on the other side.
Okay, thank you.
That's exactly what I was thinking. It's probably has two robbed. It's kind of weird.
Then it's gonna be speedo weather.
For some folks.
Yeah, I had the blue one on, you know, and everybody's gonna be wearing green.
I started to go in the marine myself.
That's his ability.
But in true rebel form, I said, no, I'm in but the green. It's a character flaw. Everybody else goes, that felt green.
What was they? You talk about.
Good morning. Are you Alexis Bourgeois Cooper?
Yes.
And Ms. Bourgeois Cooper was previously in court, entered a plea of guilty to the state jail felony offense of theft of property. The agreement was for a cap of 12 months in the state jail prison. I received that pre-sentence report. If you both had an opportunity to review the report.
Defense has your honor.
State has to,
Any additions or corrections?
None from defense.
not from the state, Your Honor.
All right, then.
Your Honor, I do have one brief witness, if the court will allow me.
Sure. Go ahead. You can call your
The
witness.
state calls Jennifer Shearer.
Jennifer Shearer. And Ms. Bourgeois Cooper, if you'll just kind of step just to the corner right there, closer, there you go. Ms. Shearer, you can come on up. Good morning, ma'am. Morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You may proceed.
Would you please state your full name for the court reporter?
From Marie Shear.
And Ms. Shearer, how are you employed?
I work at HEB and I'm with the loss prevention department.
How long have you been with the loss prevention department?
5 years.
And have, through your employment as a loss prevention officer with HEB, have you become familiar with the defendant Alexis Bourgeois Cooper?
Yes.
Please explain briefly to the court how you have come to be familiar with her.
She originally came on our radar back in February of 24 when she started stealing from our stores in Montgomery County. And then she was pulled over shortly after stealing at a Conroe store. And that's how we were able to find her.
And you understand that she's already pled guilty today to a state jail felony level theft for $3,547 worth of cosmetics and makeup from a H-E-B store in Port Arthur. You understand that, correct?
That's correct.
And she committed that offense along with co-defendants Katira Green and Monique Wynn. Please briefly tell the court your familiarization with Katira Green and Monique Wynn.
Both of those parties are part of an organized retail crime, and it's that group that we've been following about at the same time. And they have in Houston area, Katarina Green has for stealing from our stores about $56,000 worth of cosmetics, and then Monique.
Your Honor, I just object to any co-defendants' restitution amounts or what they've pled guilty to or found guilty of.
That's overruled. Go ahead.
And then Monique Wynn was about $42,000. And they're part of a ring that was hitting our area for a short period of time.
During the period of February the 24th through April the 24th, how many actual thefts did your investigation link to the defendant, Ms. Cooper?
10 events.
For a total loss of how much?
$8,956.50.
Now, for the entire ring, what approximate dollar amount would you put on? Well, let's break it down. What about for Wynn, defendant Wynn? How much would you attribute to her?
About $42,800.
And for the defendant Green, how much would you attribute to her?
$56,000.
Is it fair to say, in your opinion, that this group has been operating as an organized retail theft ring?
Yes.
And have you, in your 5 years of experience in loss prevention, have you, how would you rank this endeavor?
This is about the second highest ring we've had in HEB.
And you prepared a report?
Yes.
Okay, and you reviewed that report
That is
prior to testifying here today?
Yes.
All right, I'll pass the research.
Thank
No
you.
questions, Your Honor.
Thank you, ma'am. You can have a seat.
Judge, just if I may, I don't know what I was thinking today that I agreed to a cap of 12 months. I certainly see how the court would be inclined to give this defendant more than 12 months, Judge. Well, actually, I do know what I was thinking. If you look at her criminal history, she actually has not been to prison before. She's got a number of misdemeanor thefts, at least theft arrests.
Not enough felonies that have actually been convicted and followed through that would get enhanced either. So, I mean, I could see my initial thought was the same. I wasn't quite sure where this came from. But I can see that it's not really enhanceable at this point based on any other felonies. So, Mr. Lane.
Well, Your Honor, obviously, we're asking the court to follow the agreement that was entered. The court does have the ability to sentence her to 12 months in the state jail. She did have a 1244 in Harris County that she did 10 months in the state, in the county jail. She does have a pending case out of Hidalgo County. What had happened back in 2019 and 2021 is her father and her grandmother died. And then she did get involved with these thefts. That was a major setback for her. She does have custody of 3 children. She is a phlebotomist and has some other skills that she can earn money with. So we're asking that you follow it. She has a family law hearing that's the 24th of this month. We would ask you to sentence her to 10 months in the state jail.
Mr.
Oh,
Coleman.
we'd ask for the entire 12 months, Judge. Excuse me. I think she's benefiting from Mr. Lane.
Is that who is it? What is she?
She's benefiting from Mr. Lane's negotiation with me in working me down to a cap of 12. I'd ask for the entire 12, Judge.
Ms. Bourgeois Cooper, one of the things that stood out to me in your pre-sentence report, well, a couple of things. One, your criminal history is ridiculous. It's when I start having to turn page after page after page, that's a problem. And your version of this about I didn't really know what was going on, and I just went with somebody at the store, and I didn't know what county what I was in. You didn't know what county you were in because y'all were going from county to county to county, and still you're not going to help yourself by saying anything right now, okay? Because Ms. Shear was just here and has you on video at other stores doing the same thing. So I don't dispute what she said under oath at all. I think Mr. Lane did an amazing job for you, and you are very lucky because he got you the cap of 12 months because you deserve a lot more, in my opinion. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. And in cause number 24 DCCR 1296, find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of property. Sentence you to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lane. And all I can tell you, Ms. Bourgeois Cooper, is that I hope you learn your lesson while you're in state jail and stop all of the stealing, because each time you do it, this is only going to get worse. It's going to get enhanced. You're going to get more time. At this point, you now have, I think, 2 felony convictions, and that's going to start adding up. And you're going to end up with a lot more time and going to TDC instead of state jail. Do you understand? All right, and go back to the bailiff. Ma'am, those kids.
I love you, lady. Now. You can here.
Yeah, we just knew that it was going to be. Mr. Kimler, were you able to, okay. What,
She's looking now.
okay. See, I'm sorry.
What's not outside?
What's the name? I'm sorry, what page? Oh, I see, Brandon Lewing. We're gonna reset Brandon Lewing. Thank you. Ms. Malfino, Mr. Kimler was hired on Mr. Lewing's case. It was Mr. Parker's, and so we're gonna reset that one.
This shows, it is my intention on that one to proceed on the second degree. It shows state jail, but so that everyone.
Okay, thank you. Mr. Parker, you got Donald Cogdill?
He's on the other side. If we can, I guess we need to get him over here. I've gone and talked to him about a potential offer that we needed to discuss with you before we sign him up, but
Do you
I
want
don't
me
think
to
he'll
hold
take
it?
it. Yeah, if we can,
I'll hold it.
Can they bring him over here though?
Well, let me get some of the other ones
Okay,
on.
okay, that's fine.
here, and then we'll get it in a second.
Okay.
We've got, what about Matthew Smith?
It's a plea.
Is he over here?
Yes.
Let's get Matthew Smith, please.
That was weird. I looked at the camera when you grabbed it, it was delayed. You're out of my hand, like.
Oh, is it delayed?
Delayed a little bit, yeah. Oh.
So, good morning. Are you Matthew Smith?
Yes,
And Mr. Smith, I need you to speak up, please. So I can hear you, and so the court reporter can hear you, okay?
ma'am.
Thank you. Mr. Parker, will your client waive the reading of the indictment?
Hey, will, Your Honor?
Mr. Smith, in cause number 26, DCCR 0073, you're charged with the state jail felony offense of theft of material, copper, And that's from December 8th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Is there a fine?
There's not a fine, but it's supposed to be restitution, which I don't know. We didn't have.
So there will be restitution that will be determined for sentencing?
The owner has never turned in a restitution, Your Honor.
Okay,
This is copper from a business.
right.
There might have been insurance coverage, but there's never been a form turned in by the owner.
So would you want to waive PSI and go forward, or do you want me to set it for a PSI with restitution to be determined so that if there is some, they can get that to y'all before sentencing?
Well, PSI would be good. Thank
So
you, Judge.
if there's any restitution, then you would be ordered to pay whatever that amount is. Do you understand? As part of your probation?
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do that pre-sentence report and see if there's any restitution that they can determine between now and then we'll come back later for sentencing. Ms. French, what is the state's position with regard to me reducing the bond based on the nature of that plea agreement for sentencing?
It's 30 days, Your Honor. Whatever time he gets, he'll get credit for.
Well, if it's a
Probation, it's a
if
probation.
it's a deferred probation, typically just, so you haven't been in here.
I'm so sorry. I was thinking of another 20-month term.
Yeah, it's
Moving on to the next one. Sorry. I'll defer to the court.
no issues that you see me doing that. So, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond to $1,000, but I'm going to make that a personal bond. And so what that means is you're not going to have to pay the $1,000 to get out of jail. You're just going to get out of jail today. But there's some very important things about that. The first is that the first thing you do when you get out of jail is go to the probation department so they can start that process to do that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. Do you understand?
Yes, Your Honor.
Also, if you're arrested for anything between now and when you come back for sentencing, you obviously run the risk of me not accepting the plea agreement and things would be worse. Do you understand that as well?
Yes, Your Honor.
All right, then we'll see you back at sentencing. Probation is going to give you some paperwork in just a minute so that you know exactly where to go when you're released today, okay? All right, you go back with the bailiff. Mr. Radford on Floyd Torrin.
Yes, ma'am, it's a plea. He signed up.
I got it, Floyd Torrin.
Yes, Lord.
And are we on both?
Yes, ma'am. We're pleading on both. It's
Okay.
counts 1 and 2. Abandoned the habituals. I have some letters and some documents I would like to submit and send in the supplemental PSO. Go ahead and need you to sign this with the opportunities.
Ready?
That's right. Yeah.
Oh, okay, there was an amendment to the indictment. Change to run. One of them says that.
Do you want me to email? I'm just going on council now too.
Thank you. Good morning, sir. Are you Floyd Torrin?
Yes, ma'am.
And Mr. Radford, will your client waive the formal reading of the indictment in each case?
Yes, ma'am. He will.
Mr. Torrin, in clause number 25 DCCR 0794, you're charged with a third-degree felony offense of attempt to commit theft or property from an ATM. and that's from May 10th of 2025. The indictment alleges in count 2 that you were convicted of the felony of possession of a controlled substance, a second-degree felony, August 16th of 1999. How do you plead to that charge?
Guilty.
And is that prior conviction true? Did you enter your pleas of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with? All right, give me just a second and I'll get that. The efficiency of going. All right, then, Mr. Torrent, in cause number 25 DCCR 1152, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. The indictment alleges the same prior conviction of possession of a controlled substance in count 2. And how do you plead to that charge?
Guilty.
And again, is that prior conviction true? Did you enter your plea of guilty and true, in this case, freely and voluntarily, and because you did what they've charged you with? Each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of these cases is that, the agreement was that the state allowed you to plead only on counts 1 and 2. And that your punishment is the full range of punishment, which is a second-degree felony, between 2 years and up to 20 years up to the court. Knowing that had you gone on the full indictment, you would be looking at a habitual status, which is 25 to life. Is that your understanding of your agreement?
Yes.
I want to make sure you understand you have every right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving it up to me, and also waiving your right to appeal as long as I stay within that 2 to 20 range. Do you understand? And is that what you want to do?
Yes, ma'am.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Mr. Torrent is not competent?
No, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Also find that you entered those pleas of true to counts 2 freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Radford, and he'll get it to me so that I can review, and he'll present more, whatever, that day when we come back for sentencing. All right?
Judge, I'm going to have some documents I will present.
Thank you.
I will
Thank you.
email them to the clerk and CC Mr. Smith.
Okay, make sure you get them to probation, and they'll attach them with the PSI as well.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
May I be excused?
Yes, sir. Mr. Rojas? Yes and no. Brenda Sanchez, Mr. Himmler, Brenda Sanchez.
Never mind. Very indicated I wasn't hired on trade.
Okay,
I got to get the words. I told Mr. everything. He doesn't want to listen to you. That's somebody else's.
so Are we here on a bond?
She's on straight probation and it's picked up a new case. I say new case, it's 2 years old
Mr. Kim, let's file a motion to quash the indictment. Yes,
for pre-indictment delay, but
it's filed within the statute of
it's
limitations.
within the statute of limitations.
So what's the,
Well,
Basis.
there's a due process right to timely indictment. There was just a delay in the indictment, even though it's within the statute. Period.
good morning, are you Brenda Sanchez?
Yes, ma'am.
This is cause numbers 26 DCCR 0027, and then Ms. Sanchez, that's a new case of a possession of a controlled substance. And then Ms. Sanchez is on probation, and cause numbers 20-33832 and 20-34508, both of those for theft of property cases.
Yes, ma'am.
And so what are we here for today?
Well, Your Honor, we would request a hearing on the MTRP for them to try to prove up the new case. I think she's performed satisfactory as far as administrative.
So if there's no agreement, we just need to go through the motions?
Well, yes, ma'am.
Okay. Ms. Sanchez, lift the hand, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will she waive the formal reading of the motions in each of the cases?
So,
Let's see. Ms. Sanchez, in cause number 20-33832, I have a motion to revoke your community supervision. It shows that you were placed on probation February 22nd of 2021 for the offense of felony theft that had been enhanced to a third-degree felony, and that was a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Just a second. One. All right, I'm there. And then in cause number 20-34508, I also have a motion to revoke your community supervision. It shows that you were placed on probation February 22nd of 2021 for the state jail felony offense of felony theft that was enhanced to a third degree. That was also a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count one in each motion alleges that you committed the new offense of possession of a controlled substance, penalty group 1, in an amount of between 4 grams and up to 200 grams, August 15th of 2024 in Jefferson County, Texas. And is that true or not true?
No, ma'am.
True or not true?
Well,
I just need you to
not
say the
true,
word, true or not true.
Not true.
Thank you.
Okay.
And then count 2 alleges in each case that you failed to avoid persons or places of disreputable or harmful character, specifically by failing to avoid presence at a location where a criminal act was being committed, by residing at a location identified by the Beaumont Police Department as a narcotics stash and distribution location. And is that true or not true?
Not true.
Count 3 in each case alleges that you possessed a controlled substance, namely Dilaudid or hydromorphone, without a prescription, August 15th of 2024. And is that true or not true?
True.
that is true.
Well, I mean, I don't think possession, but it was my friend's medication that was at my house.
Okay.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Not true.
All right, so I'm going to show that you entered a plea of true to count 3. Did you plead true to count 3 freely and voluntarily?
Yes.
Okay, so I'm going to find that count true, find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated report. We'll get it set for a hearing. The state intends to bring witnesses with regard to the new offense.
Yes, Judge, yes. Should take very many, and it shouldn't take very long. I know, on the heels of yesterday.
I'm a little gun shy on that, Mr.
Yesterday.
Coleman. We'll set it, an 11 o'clock hearing. I'm talking, Mr. Kimler. So I'll set it at an 11 o'clock hearing. And here's the important thing, Mr. Kimler, as we've talked about before. If there's something that comes up and there's some change in status of her pleading true or not true without the necessity of a hearing, please let Mr. Coleman know that. I don't want officers showing up here and wasting their time, and then all of a sudden there's a deal made at the last minute, okay?
I suspect that's your honor, but I do think that as far as possession goes, I understand the circumstances that she's explained them to me. I don't want any kind of perception by the court that she's misrepresenting things, but it may be better that I change that to not true.
Yes, sir.
On three.
Okay. So there will be,
There's
please
an
and not true. It's all right. We'll get to that.
explanation for that.
Please and not true on all of the counts. State will bring witnesses on those, and we'll get it set for a hearing. We'll get an updated pre-sentence report. Obviously, Ms. Sanchez, anything that you think is important for me to know, get that information to Mr. Kimler. He'll present it to me on your behalf when we come for the hearing. You can go back with the bail. Oh, wait. We need a fingerprint.
We can back to talk.
I know. Okay. So with regard to the motion to quash, do you just want me to take that up?
I just think it really, so.
I mean, if it was within the statute of limitations and there's no, I mean, is there some actual?
And that brings today's courtroom session to a close. From probation opportunities to serious warnings about prison time, every decision came with real consequences. Judge Raquel West made one thing clear: second chances are possible, but they come with responsibility. What do you think about the rulings in today's cases? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more courtroom breakdowns.